Good morning. It's Thursday, the 25th day of February, 2021. Civil Court at 9:30 before the Honorable Chief Justice, Civil Jurisdiction 2019, number 92, day 2 of the Corporation of Hamilton and the Attorney General and others. Mr. Mark Deal for the applicant, Mr. Gregory Howard for the respondent.
Yes, good morning.
Good morning, my lord.
Morning, my lord.
Mr. Howard, if you're ready, please proceed.
Yes. Thank you. We're picking up at page 11 of our submissions.
Yes.
If the corporation is able to show that it has standing to challenge the legislature's changes to its statute, it has to overcome other hurdles. First, in order to establish the claimed violation of Section 13, the corporation must prove that the legislation deprives them of property. However, we submit that the legislation doesn't do so because it does not change the identity of the corporation or its ownership rights. A mayor and councillor will still continue to administer the property of the corporation in accordance with the statute. So that all the cases, one of the oddities of this proceeding is that any law we've been able to present all deals with private rights. And even the Lawrence case, which appears to be the high point of the case law presented on the issue of ownership, that's the case which deals with a St. Kitts and Nevis and a bank which was partially had majority shareholdings. That's at page 26 or tab 26 of the.
I have it.
Yes. So even that case, my lord, is if you look at page 923 in the proceeding, it clearly identifies, or at the report of the case, in the middle of the page, it says, on 13th September 1958, the St. Kitts Industrial Bank Limited was duly incorporated under the laws of the country. And then it goes on, refers to the company's articles of association, and then it refers to an act of the Special Provisions Act of the legislature. So which then the court found interfered with the constitutional property rights of that limited company. So we'd submit that this case, in all the cases relating to Section 13 or its equivalent in the Commonwealth Caribbean constitutions and others, are distinguishable by the fact that they deal with the taking of private property. And so
it was analyzed. That decision, if you look at page 929D onwards, they refer to an Indian decision in Chiranjit Lal Chaudhary and Union of India, where the Indian court had held that the mere fact that there was a control taken over by government, which denied the shareholders their contractual rights under the bylaws or the articles of association of a company, did not amount to a taking. And then they referred to the commentary on that decision by Mr. Jain in book called Indian Constitutional Law, where he said that that would be a very rare circumstance. And as I understand the Lawrence case, the Court of Appeal in the Lawrence case decided to adopt the commentary by Mr. Jain that the denial to a shareholder of the shareholder's contractual right to elect amounts to deprivation of property. If that's the right analysis, of course, arguably doesn't apply to us because no shareholders being denied their right as such, although it's analogous, I would say. What they seem to derive from this case is Ordinarily, it's perfectly true that the notion of taking as a literal concept would require the property being transferred from A to B. And the cases dealing with the issue of control seem to suggest that in certain circumstances where the control is substantial, for example, where it denies the shareholders their contractual rights to elect management, may amount to deprivation.
No, I think that is the general tenor of the law in this case. So let me move to that point of control.
Yes, I think that is one of the substantial points which they make, is that I mean, clearly property hasn't been transferred. The property remains with the corporation.
Right.
The only way they can argue that there's been deprivation is the issue of control. They say,
Exactly.
as I understand it, they say because indirectly the minister can control appointments, indirectly, therefore he controls the management, and he can give directions and the like. And that amounts to the notion of taking under the Constitution, and by analogy to cases like Lawrence. And I think your burden would be to say why that notion doesn't apply to a public corporation.
Right. So and that's the second point at about page 11 of our submissions, which we flesh out in some detail there with case references. But in essence, the Amendment Acts between 2010 and 2018, we submit, are authorized by the legislature's ability, in essence, its responsibility as the initiator of the statute, to have control over public bodies in the public interest. And this is really, we submit, a matter of parliamentary sovereignty. The legislature's control of the corporation is affected in the amendment legislation in three essential ways. The minister has to approve council resolutions. That's section 711 in the consolidated legislation. The minister can give directions under 7AA, and the minister can take temporary stewardship, and that is 7B6 of the legislation. But the approvals or otherwise of the council resolutions are made on the record. So as a matter of course, the council submits resolutions to the minister, and the minister, in the usual course, will indicate a marginal note saying approved, and or otherwise in certain cases, or make a comment. And so that's on resolutions, the approval of resolutions. We submit that is no more than executive oversight of a statutory body, which is authorized by the legislation and is not an unconstitutional control. We'll look at the legislation or the case law on that. But in the case, so any directions of the minister are required to be in writing, and they require under the legislation prior consultation with the corporation. The legislation doesn't require what the content of the consultation will be, but there's a mechanism in cases of consultation. There obviously is building up a body of law now of what the content of consultation should be. So we submit that that such directions, their requirement of writing and the requirement of prior consultation do not result in a control such that it would overcome the ability of Parliament to control a statutory body. And the third type of control, which is authorized by the legislation, are stewardship orders. And those are required to be published in the official gazette. So that is, and there are preconditions for its exercise, obviously, and those have been fleshed out in cases before the court. But the preconditions are a disarray. We can go through. We went through them briefly yesterday. I don't think, for the purposes of this discussion of control, that we need to look at them. But there are preconditions, and importantly, we submit with all those types of controls, they are subject. They're exercised by the executive pursuant to statute, and they are subject to review by the courts, such that if, in the case of executive overreach, a failure to approve something which the corporation believes its members believe ought to be approved, can be subject to a challenge to the court on ordinary judicial review principles.
Doesn't the same analysis apply in the Lawrence case? In the Lawrence case, what was done was authorized by the legislature. They in fact passed a statute in one day, and presumably that would have been open to judicial review.
It might have been open to judicial review, but there was also a constitutional challenge as well, and the court determined the case on the matter of constitution, but on the matter of the Constitution, the corporation raises a point that it's been denied the access to the courts, or it's what it claims are its Section 1 rights of the due process of law. And we submit that the ordinary principles of court access and judicial review apply to any of these exercises of executive control.
So just, do you see a conceptual distinction between the issue of control in relation to private commercial enterprises, like, for example, the bank in the Lawrence case, and the Corporation of Hamilton, which is a public body? And if so, what is the basis of that conceptual distinction?
Well, I hinted at that in the beginning of my remarks on this second point, in that the central government, the legislature itself, having established a public body and given it certain statutory powers, has the responsibility in the public interest to make sure that that public body operates in accordance with the law which it has established. So the conceptual difference is that a private company may operate in any way within the general regulatory environment where it conducts its business in any way that will favor its shareholders, and conduct any private business that is permitted by its articles of incorporation without fear of interference from the central government in its private affairs. However, the conceptual difference which I've just said applies to private companies is of a different nature altogether in public statutory corporations, such as the Corporation of Hamilton. It is in every case subject for its very being on an act of the legislature and the it is responsibility of the legislature itself to devolve power, take away authority, as the case may be, as it sees the public interest. So a private body, again, I refer back to the ex parte Fewings statement of the essential difference between private bodies, such as private companies, and public companies, which are of a different nature altogether. So that we submit that the controls that are in place in the legislation currently for the Corporation of Hamilton are authorized by the central government's control of inferior government bodies. And it is the responsibility of the central government to make sure that adequate controls are in place, financial and governance. And that is something which would be almost automatically overreach if they were applied to a private company, but which are authorized and necessary, we submit, in the case of public bodies. So that is the conceptual difference between those different kinds of entities.
Yes.
So in support of my contention that such regulation by the central government is permitted by law and is not unconstitutional, we would refer to the Campbell-Rodriguez case, which is at tab 19 of the of our Book of Authorities.
Yes.
Now, if you look at paragraph 18 of that, it's at the last page of the case. The court, in concluding that the construction of a public road that had the result of bypassing individuals with various rights, leasehold rights and property rights, businesses, was not an unconstitutional taking of property. The court said this: the cases on regulation provide analogies which give a measure of assistance in approaching the issues in the present appeal. It is always necessary to exercise a degree of care in relying on analogies, not to press them too far, but their lordships consider that they provide some useful guidance in deciding the issues before them. They establish clearly that there are limits to the concept of taking of property, and that some types of state action, which could linguistically be so regarded, are not to be regarded as justiciable. It is well established that measures adopted for the regulation of activity in the public interest, such as planning control or the protection of public health, will not constitute the taking of property, notwithstanding the fact that they may have an adverse economic impact on the owners of certain properties. So too, in the Jamaican appeal of Panton v. Minister of Finance 2001, the board held that the assumption under statutory powers by the Minister of Finance of the temporary management of certain companies whose affairs were under investigation did not constitute a taking of the appellant's property. It is the respondent's case that the replacement of an existing highway by an improved road on which a toll is charged is governed by the same principle. Now, we submit that the cases on regulation referred to, such as Panton, and that Panton is the next case in our bundle. But I don't propose to take your lordship to it because it's very well established, needing no authority, that the central government is able to establish general regulatory laws that in the public interest, let's say, in the public interest as defined by health. I mean, we've seen during the time of the pandemic, the need for public health reasons. All the, all those reasons why, or permissions that the central government has as part of its public interest duties, and through the authority of the legislature, part of its parliamentary authority, all the authority that it has to govern private bodies and have restrictions on private individuals in certain cases that are justifiable, apply more so without the need for justification of creatures of statute. So we submit that there is a very good reason why all the cases seem to deal with matters that touch on private rights and private properties. We say it goes without saying, needing no authority in a sense, that a public body is subject to the control and direction of the central government. If there is executive overreach, that is to be determined not by a constitutional claim that its control has been taken away, but through the general avenues for a challenge that any person may make of such executive overreach. And that is through the judicial review procedure. So we, in essence, or in summary, our point on the question of control is that it's no more than what the central government is authorized to do, is permitted to do, and has a responsibility to do as its responsibility for control of statutory bodies. And the question, the third point which follows on that, and it's raised in the Campbell-Rodriguez case, is the question of justiciability. I mean, how, so the question, if there, not only on the question of crafting should there be a finding by a court? We haven't been pointed to any such finding by any court that such control or a change to legislation which takes property from a public corporation. If that were to be found to be unconstitutional, the question of justiciability arises. I mean, it goes throughout this whole proceeding, not only in crafting an appropriate remedy, even an appropriate declaratory remedy, but is, the question we submit is of marginal justiciability.
You say it's a matter of politics as opposed to law.
Exactly, it's public. These are matters of pure public policy, the control of central government of statutory bodies. I mean, it goes without saying that the legislature, if we believe in parliamentary supremacy, if we believe in that overblown phrase, the rule of law, then we have to believe that the government can control this statutory body. If there were to be some finding in some court somewhere, God forbid in this one, that there is some super right of the Corporation of Hamilton to have its own assets and to be able to use them in perpetuity without the control of the central government, then we're no longer believing in parliamentary supremacy and the rule of law.
Well, the only route we get to this stage is if we didn't have a written constitution, your argument would be absolutely 100% correct. It's only as a result of the written constitution there is an application to rely upon constitutional rights, and they say that even a public body can rely upon them.
Of course, we're all subject to the corporation, including the corporation and the central government are both sheltering under the protections of the Constitution. The question is, there's an intermediary body between that sheltering roof of the Constitution and the corporation, and that is the government of Bermuda. So an individual can shelter directly under the Constitution, but the corporation has to answer first to the statutory purposes set out by the corporation. But that may seem to beg the question. I understand that. I mean, the very question raised in this proceeding is whether the Corporation of Hamilton can claim that its property has been taken, and if not taken, subject to such a degree of control that it is a taking under Section 13. And leaving aside the questions of whether a remedy can be crafted, we say it cannot, by virtue of these controls being no more than what is necessary for the central government to exercise its oversight of this public body.
So interestingly, Mr. Deal appeared to accept that there was no objection to the central government having a say. On one basis, the dispute appears to be the level of control. He said we have no objection to representatives being on the council. I think what is objected to is the majority vote.
Mm-hmm. So if the court, for instance,
that's quite a narrow dispute on one basis.
Right. It is narrow in a sense, because if the court were to grant a declaration that all the amendments, or the three that I've named, for instance, that would have the effect of returning the corporation to the 1923 Act pre-2010. And there are also controls in the 1923 Act. These have...
What are the controls in the 1923 Act?
Well, it could, for one example, for instance, is that there still was a Section 38, which says that they had to, what they could make ordinances for. They didn't have absolute control over property within the limits of its town. And there were other limits. There was, it was always, the properties of the corporation were always held for municipal purposes. So if we were to return to the status quo ante, there would be no doubt lighter touch central government controls, but controls nonetheless. And we've seen by looking at the evidence in this, if the evidence is proof of nothing, it's proof that there has been a necessary reason for central government action relating to events in the corporation. The court doesn't need to go into the reasons behind it. Matters are quite contentious. I recall a former Chief Justice in the jurisdiction where I practiced for many years saying that in a very local dispute, the smaller the sewer, the fiercer the rats. And in a sense, it's been the conflict has been shown that there is a need, however the conflict came about, for central government regulatory oversight. And that's why the good governance proceedings came, or this changes were made. So these are pure matters of policy, government's policy, and are which entirely the realm of the central government to do, of course, subject to constitutional norms. And we suggest, our submission is that in no way do these controls that have been established interfere with the constitutional norm of acceptable government control of public bodies. The next point we make is in relation to section 13(3) of the Constitution, and that is at page 12, the bottom of page 12 of our submissions. We submit that that section applies, and we have not been able to find, it's a theme in this case, any law that deals with a similar kind of provision or the concept generally. However, there is a reference to this section in the decision of the Chief Justice at tab 10 in our Book of Authorities.
Yes.
And that was a challenge to a stewardship order, and we're looking at paragraph 51. So, yeah, I can let your lordship read the paragraph.
Yes.
Now, the objection which counsel took to that point when we raised it was that only statutory corporations wholly financed by public funds are debarred from seeking relief. That's not quite what the legislation reads. It says in which no
monies have been invested other than monies provided from public funds.
Exactly.
Well, that was the point I was raising with
Yes.
Mr. Deal.
Yes.
And one can see investment ordinarily means buying shares and the like. And he thought that lending money to the corporation would amount as investment. So if the bank goes to the Bank of Bermuda, HSBC, and borrows money, presumably that, he says, would be investment.
Mm-hmm. Well, certainly there would be
There'd be creditors.
I'm not sure it would be I wouldn't characterize that in law as an investment. It is a loan agreement and is a matter of contract. And there would be an obligation and a charge and a requirement of the public body to pay the funds back. And so that's a matter of contract, and it would be enforceable clearly.
What about ratepayers paying rates? Are they investors?
Well, my submission on that is that those rates start out in the hands of the ratepayer as private money, and then they become public as soon as they enter the coffers of the corporation. So
you say it's not investment because they're not expecting anything back other than.
No, it's clearly not an investment, and in this and just to on the point of whether a loan is an investment, it clearly is not. There's a contractual right to pay with a contractual right to receive interest or whatever other kind of credit there might be, but it's not an investment.
So why was Chief Justice Caveley hesitant?
Well, I don't think Chief Justice Caveley dealt at all with the constitutional issues. He deferred that. So the entire tenor of that case was whether the stewardship, and the court actually granted an order to the minister staying the proceeding until the council was constituted constituted differently under a new election. The stewardship had been necessary in that case because of such disarray and disagreement among county. Although there was argument on the Constitution, the court declined to make a ruling on it. And he was throwing, just in general terms, per incurium, perhaps, just pouring cold water on the argument because it wasn't something he was prepared to deal with. However, we submit that this provision has tremendous relevance. We're somewhat hampered in our consideration of it by the fact that there isn't any law that we've been able to find. There isn't even a good, and we've.
What's the rationale behind it? That section, the Section 13 protection is really for private interests, not public bodies.
Exactly. So this, I think, is the drafters of the Constitution way of saying that public bodies can't benefit from the very thing that can't benefit from the provisions for protection of private individual rights when they even when they are just have their lifeblood from public funds. I think the only question for me, it seems perfectly obvious what the legislator is doing, and that sort of final, oh, by the way, nothing contained in or done under the authority of any law is held to be inconsistent with or in contravention of Section 1, to the extent that the law makes provision for the compulsory taking of interest or property where no public, and then it continues, we've read so it seems to preclude public bodies from making a claim that their assets somehow can't be disturbed or taken by the central government.
If they're made under the relevant law, and you would say that here, your position is that there hasn't been any taking,
right?
That even there was taking, it would not be actionable as a result of 13.3.
That's our submission. And it would be a first instance, as far as I know, consideration of that section. It seems to be the case that everybody else except the corporation perhaps thinks it's settled law that a public body can't make a claim for the taking of its property. But
on one basis, that is talking about, obviously the government can pass, and there is legislation in relation to compulsory acquisition of property. And if the government makes those orders in relation to private property, they're entitled to compensation.
Correct.
And what they seem to be saying is that in relation to a public body, where there hasn't been no investment other than by public funds, the public body can't make a claim in relation to it.
Correct. It can't demand that the provisions of the law requiring that provisions of the previous Section 1 cannot be used in, or they're not entitled to benefit from that it be by law and that there be a mechanism for recovery. They can't benefit for those provisions. And that makes perfect sense. I mean, as we've seen.
Would it be claimed by one public body against another? It'll just be simply internal transfer of funds. Exactly.
That is some of the justiciable kind of issues that you would get into in this case. There are many analogies and potential scenarios that one could explore in government's relation with statutory bodies, but in effect, it has to be treated as a matter of the legislature exercising control over public bodies. the question arises in the application of section 13.3 of what is public monies, and public monies other than monies provided from public funds. And the only question for me, the most difficult matter to consider, which I think can be resolved in this way, as far as the meaning of public funds, is that any funds from any source, whether it's a donation, whether it is by a rate, a tax, a levy, as soon as it enters the hands of the corporation, it's public funds to be used for public purposes, permitted by the legislation. So we can resolve that difficulty, which the corporation may raise, that just say, well, what about a private benefactor? And the Hazel and Hammersmith case dealt with that very issue. The court raised that. Well, what about a generous donation from a ratepayer or some other person? That has to be used only in accordance with the Act. It doesn't have some separate life of itself that continues on once it gets into the hands of the corporation. So we submit that section 13.3 applies and is a bar to a claim by the corporation under 13.1.
Yes.
Our next point is on section 1, the claim under section 1 of the Constitution, protection of the law. This has been canvassed in evidence yesterday, and we propose to say only this, that Inchcup is binding on this court. It's been confirmed recently in Ferguson, and the court's statement in that case is not under review in the Privy Council, although the case is before the Privy Council. And in Great Bay, the Privy Council declined to consider the issue. So that is the law in Bermuda.
What about this submission by Mr. Deal that it was obiter, and given that it was obiter, that I am confronted with two conflicting decisions of the Court of Appeal, the Malpas and Farias case, which he says, despite the fact that the Court of Appeal thought that was per incurium and without any basis, that I should follow that case. Well, what about just the contention that the case, the authority is per incurium? And
I think that thank you. That I'm happy to address that very, very briefly. I think the Malpas case made a decision, and the court in Inchcup, more recently in time to us than the Malpas case, considered Malpas and made a ruling that section 1 is not, the rights enumerated there are not individually enforceable. That, I think, settles the issue. A court more recently to that one has had Malpas before it. It's listed in the cases that the court had before it, and it made a decision. That is the most recent pronouncement by the Court of Appeal.
Am I bound by the Court of Appeal's categorization in Inchcup that Malpas was per incurium?
As far as I understand the word per incurium, is that the court did not have all the relevant law in front of it, and the court in Inchcup the court in Inchcup was referred to the appropriate cases, Olivier and the others, and therefore I think you are able to accept that the court in Inchcup.
If the Court of Appeal says that it was per incurium, I mean, I must say, my initial reaction is I'm bound by it, by the decision that the previous decision was per incurium. It would be odd for a judge at the Supreme Court to say, yes, the Court of Appeal has taken the view in 3 decisions, but I'd reject their categorization. But obviously I have to
that obviously without your lordship deciding the issue, I think your hands are tied in this case. It is a matter in which the Court of Appeal has spoken and then confirmed it. It appears to be settled law. If you can look at the statement in Ferguson, it seems to be settled. If your lordship would be unsettling the law if you were to do that, which I think would be contrary to the role of stare decisis. That's all I propose to say on this section, the applicability of Section 1. We have provided cases in our submissions, and the section relating to the European case law relating to and that this is at page 15 and following of our submissions. And I won't refer your lordship to any of the individual cases, except one perhaps. But the tenor of those cases is
this
that
is on the basis that Section 1 does apply.
Right. Right. Exactly. So maybe I don't need to having.
But there seem to be some authorities which say that even if it's not directly applicable, it still has certain force.
Well, we don't argue that. With respect to my friend's argument, they seem to say that it means it's just a preamble, therefore it means nothing, or it has a bunch of individually enforceable rights with constitutional force. And we say that there is a middle ground, which is clearly what the courts have said, that it's not a mere preamble. It has the force of law. It's an aid to interpretation to the actual enforceable rights. So that's the middle ground, which I think where the courts have landed on Section 1 in the Bermuda Constitution.
I mean, the Caribbean Court of Justice has gone in a slightly different way. I mean, the Caribbean Court of Justice has taken if I call it the preamble provision, and said it's much wider than the rights which are given in the subsequent provision. Say, for example, the protection of law. They say the protection of law can't be just limited to the accused in the criminal proceedings, as that limited protection is given, and the parties in civil proceedings. That is much wider than that, and therefore one has to not worry too much about the fact that he uses the word whereas, and it seems as though it's an introductory provision in order to give the Constitution its full breadth.
Well,
One just simply looks at the intent of Section 1 in ours and gives it a full effect. I mean, the Privy Council hasn't gone that far, but it certainly seems to be the movement in the Caribbean Court of Justice.
The trajectory of the interpretation of Section 1 in the Commonwealth Caribbean, part of it may be that there are slightly different uses of language in there. I noticed in looking at one of the cases before us that the Jamaica Section 1, for instance, doesn't, it has the whereas lists the rights, but it doesn't have that second part, which Section 1 of the Bermuda Constitution has, that says that the other rights, these are to be interpreted in accordance with the following rights, the subsequent rights. So that's an example, I think, of some of the differences which may lead to a more broad and purposive analysis of Section 1 in those jurisdictions. But for present purposes, we submit that the law for now is settled, and it's an aid to interpretation that has legal effect but does not have individually enforceable rights. The final matter to which I would refer your lordship is the consultation, the issue of consultation, which is at our submissions.
Just put it in context, how this arises, issue of consultation.
Well, the government undertook consultation with the corporation and members of the public. I believe the allegation is that that consultation was inadequate. And our submission is that there was no statutory requirement for consultation, that the government fulfilled any common law duty that it may have had to the corporation and ratepayers to by conducting a consultation, and that there's that the claim that it was inadequate is not something that would prevent the central government from enacting the changes that it did. And we refer to various authorities on that point, which we can refer your lordship to.
Yes, please do.
So this is at tab 28 of our book of authorities. And that is the Supreme Court decision of 2014, and we refer to the judgment of Lord Reed at page 18, paragraph 35. Now, that was a case where the Mosley case was a case where there was a statutory duty to consult. And that is not an uncommon, I understand, feature of legislation involving local authorities. And this was a...
What's the position in Bermuda? What's the position with our case?
Well, the only statutory duty to consult is when the minister is giving directions to the corporation. And that's not in, there's no allegation in this case that any particular direction was done without consultation. So there's no violation of a statute in this case. And this, I understand, the question of consultation doesn't go to the corporation's case on the Constitution. It says that I suppose that, well, I'll let them make their case, but I understand they're saying that the consultation, there was some duty to consult and there was no proper consultation or inadequate consultation. But it's clear that, as Lord Reed says, and he deals with it, paragraph 30, starting at 34, I am generally in agreement with Lord Wilson, but would prefer to express my analysis of the relevant law in a way which lays less emphasis upon the common law duty to act fairly and more upon the statutory context and purpose of the particular duty of consultation with which we are concerned. And he goes on to say, the common law imposes a general duty of procedural fairness upon public authorities exercising a wide range of functions which affect the interest of individuals. But the content of that duty varies almost infinitely depending upon the circumstances. There is, however, no general common law duty to consult persons who may be affected by a measure before it is adopted. And he goes on to say, to quote from or refer to the Bapio case, and that is attached next. A duty of consultation will, however, exist in circumstances where there is a legitimate expectation of such consultation, usually arising from an interest which is held to be sufficient to found such an expectation, or from some promise or practice of consultation. The general approach of the common law is illustrated in those cases. And then in the next case, Bapio at 29. And this was a case relating to changes to immigration rules and the need to consult with those who would be affected by the change to immigration rules. And the case, I would refer your lordship to paragraph 57 and the decision of, that's paragraph 57, and the reasons of Justice Maurice Kay. I too would dismiss the appeal in relation to a duty to consult and will allow it in relation to the Department of Health guidance. Add these brief. I wholly agree with Sedley. What did not arise in this case, namely the non-specific nature of the alleged duty and the lack of clear principle by which to define it. For my part, however, I would not so readily reject one of the alternative submissions made by Ms. Lang on behalf of the Home Secretary. Whilst I do agree with Sedley that the rules are susceptible to judicial review on grounds such as ultra-vires or irrationality, I doubt that as a matter of principle, a duty to consult can generally be superimposed upon a statutory rule-making procedure which requires the intended rules to be laid before Parliament and subjected to the negative resolution procedure. I tend to the view that in these circumstances, primary legislation has prescribed a well-worn, albeit often criticized procedure. They attach some significance to the fact that it has not provided an express duty of prior consultation as it has on many other occasions. The negative resolution procedure enables interested parties to press their case through Parliament, although I acknowledge that their prospects of success are historically and realistically low. So the courts, it appears, have been reluctant to impose on a duty of consultation on government as it exercises its role in lawmaking. That's our submission in this case. And that although there's certainly no statutory duty, there's no common law duty, except a duty in fairness where that issue arises. But in the legislature's exercise of its regulation making and statute making powers, there's no duty to consult, no common law duty to consult. And perhaps I'll leave the submission at that. I think that covers. There is the local case of Matthey, that's provided at the next tab. The court, per the former Chief Justice, at page 31, I think, summarizes the overall approach after canvassing the relevant law relating to consultation. In that case, it was a proposed change to, or a consultation relating to the closing of schools in the particularly contentious area of education reform. And at paragraph 110, the court says, there is, in my judgment, no basis for implying that the minister had a duty to consult before making the rules. However, there was another aspect of the case in which I think there was, if I'm correct on that, I think it was decided on other grounds, but it not decided on the issue of the duty of consultation. And
Yes.
those are my submissions, subject to anything further your lordship may have. I would end there.
Yes, thank you. Yes, thank you. Mr. Deal? I'm assuming we still have Mr. Deal with us.
I'm sorry, my lord. I started talking and was you couldn't see or hear me. My lord, my proposal would be to do as follows. There's a significant number of points that have been raised. I would obviously like to respond to them, and my suggestion, if it meets with your lordship's approval, is to in the next day or so, certainly by Monday, send your lordship some notes to save your lordship's hand. And these are important issues, and I think they need to be properly ventilated for your lordship's consideration.
The only difficulty with getting notes afterwards is that
It leads
the notes tend to go beyond what was argued. And then, in all fairness, I have to give Mr. Howard an opportunity
Yes.
to respond.
I appreciate that, my lord.
We have plenty of time. I mean,
Okay.
would it help? Do you want to take a short break to get your...
I think I wouldn't mind getting on with it. I'm completely in your lordship's hands, of course. If you want to.
No. I'm happy to continue.
I'm quite happy to get on with it, my lord.
11 o'clock, and then we'll take a short break.
Yes. Okay, my lord. So if we could kick off, if we can use perhaps as a heading for your lordship's note, is what has been, and I'll touch on this in a number of areas, but what they call the public purpose point.
Yes.
Which is obviously a point that my learned friend has dealt with. And I think, to be fair, your lordship has expressed a number of views on we need to deal with it. It seems to be a fundamental issue. The gravamen of my learned friend's case seems to be as follows, my lord. One, the corporation, I'm sorry, my lord.
Yes, thank you.
Yes, sorry, my lord. The gravamen of my learned friend's case on this point seems to be as follows. One, the corporation is an instrument of local government, exercising powers devolved upon it by central government through legislative enactment. And I hope I'm putting his case fairly. Two, those powers are conferred by the legislature and may be amended by the legislature and must be exercised for public purposes. He says such purposes here being the purposes connected with the governance of the municipality of Hamilton.
Yes.
Three, land and generally property holding powers are no exception, and they must therefore be exercised for public purposes. Four, the corporation is a public body which does not have all the powers of a natural person, i.e., compare and contrast private companies incorporated under the Companies Act,
yes,
which have recently been given quote natural person powers. Five, it follows from this that the corporation is not a person which is entitled to the right to protection against deprivation of property conferred either by Section 1, assuming it to be, which they don't accept, of course, to be independently enforceable, or by Sections 1 and 13 read together, treating Section 1 as an aid to construction, or Section 13 read on its own.
Yes.
It follows from the foregoing that it is, and I would put in quotes, unlikely, and it's to use your lordship's expression, that the corporation may assert the right to protection against such deprivation. I think that's a fair synopsis of my learned friend's case on this point. So, my lord, dealing then with those, so the point's this: even assuming the above premises are accepted, which of course we say they're not, or much of them aren't, the conclusions do not follow.
Yes.
The legislature could amend the provisions of the Companies Act, conferring natural person powers on private companies as well. And this is an important point because your lordship seemed to be quite, if I may say, quite taken with it. And then this point, my lord, that the Constitution is intended to apply to public bodies is clear from the exception set out in Section 13(3). The simple point being, my lord, that what they have here is an exception for certain public bodies that are, we will develop this point, entirely funded from, emphasis, public funds. Not with public funds, and there's an important distinction. So what that means is, my lord, is given that if there's that exception, if I can put it this way, but for that exception, it applies to everyone else. So public bodies not caught by that exception are within the ambit of Section 13. Is your lordship with me? I'm sorry, your lordship's frozen. I don't know if it's in horror at my submissions, but sorry, your lordship's feed froze.
Okay.
Did your lordship?
So, just repeat the last two sentences.
Always terrifying when you make a point and then your lordship's frozen for 30 seconds. The point is that Section 13(3) creates an exception.
No, I understand the point. Section 13(3) assumes that ordinarily public corporations would be subject to the constitutional protections.
Well, and particularly Section 13(3). My learned friend
Yes.
was trying to make the point, and I think it's a bad point, that because of Section 13(3), QED, public bodies are not are exempted from the effect of Section 13, and that's just a bad point because of the fact that Section 13(3) doesn't exempt all public bodies; it exempts those public bodies that have been funded from public funds, which we say we're not anyway. Well, we'll come on to that point. Yes. So thus not being a private company under the Companies Act does not lead to the conclusion, this is a triple negative, I think, does not lead to the conclusion that the Constitution does not apply, or that the corporation's ability to assert constitutional rights against government is negatived. Further, all public bodies have public functions. That is the nature of a public body. And thus, given the Constitution must be construed as applying to such bodies. The notion of having public functions and thus that disentitles an entity from having any or asserting constitutional rights, we would say seems to rest on an infirm basis. Yes, there really is no magic, if I can put it this way, my lord, in being an instrument of local government. That just means that it is a statute corporation established for the purpose of such government, which inheres in other premises.
I think
So-
where it may make some difference, and obviously I'd invite your assistance, is in relation to the whole issue of control.
Yeah.
As to whether in the context of central government and local authorities, obviously, we don't have a formal situation as in the United Kingdom.
Right.
But even here, in relation to the minister responsible for municipalities and the two municipalities, in relation to their relationship, how does one actually look upon it, look upon the issue of control, and whether the issue of control can lead to a conclusion that there has been an infringement of Section 13, which ordinarily can apply in the context of private commercial enterprises. But the issue is as to whether public corporations like the Corporation of Hamilton, in that context, in the context of control, are in a different category, and if so,
Well,
in what category?
let's deal with that last point, if I may say first, my lord, because with respect and based on, I hope I don't think I actually have to provide the authority, but as your lordship is familiar with the concept stated in, for example, Fisher, the Fisher Privy Council decision in Fisher, which I know your lordship is very familiar with, rights under the Constitution have to be given a general, purposive and broad construction.
Well, Fisher, as I understand it, Fisher stands for this proposition that the ordinary rules as to interpretation in relation to statute and
Yes.
in relation to instruments do not apply to constitutions, because constitutions are written with a different subject matter in mind, and one tries to give a purposeful construction to the Constitution.
Well, I would say broad and generous and purposeful are phrases that are used in Fisher, my lord.
Yes.
Consequently, or conversely, limitations are to be strictly construed. So for your lordship or my learned friend to be trying to say that for whatever reason, public bodies who are not caught under the Section 13.3 limitation or exception are still somehow removed from the benefit of protection of deprivation of property under Section 13 because they are a public body is respectfully just contrary to the clearest and highest law on this issue.
No, I think the point is slightly more subtle than that. It's not that they are not protected. The question is there as the law has developed in relation to the issue of taking, the recent cases such as the Lawrence and the Papineau case seem to suggest that there could be a deprivation of property,
yes,
when there is no transfer of assets as such,
right,
but simply because the management control has been taken away. And
yes,
those cases have to be obviously considered with care because they are fact specific. And those are cases where ordinarily there would be no question of the third party taking control of those bodies at all, because in the case of Papineau, in the case of Lawrence, the government would have no, on the face of it, reason for taking control over the management, and likewise in relation to the Lawrence case, but they did. Here, and in those limited context, it was held that if there is a substantial interference with the contractual arrangement in relation to management, then that could be considered deprivation of property. I think the limited issue in that context is to what extent that analysis applies to central government and the Corporation of Hamilton when there is an inherent control to some extent by the central government over the corporation.
That, my lord, you think your lordship has put his finger right on it. Emphasis on the words "to some extent." It becomes a question of fact and degree. So, for example, and unfortunately, your lordship doesn't have this. I would refer your lordship in any event, because I'm going to mention it later, to the Bermuda National Trust Act, where, for example, under that legislation, the minister can appoint a number of officers to the board of trustees. But that, for example, in that case, is a minority. Now, under our situation, the minister already had the ability from either him or his representative to attend meetings, for example. But that is not, obviously, has not, this progression of encroachment on the corporation hasn't been enough as far as the government is concerned. So what instead they want to do, and I don't think there's any dispute on this fact, is they want to take over, essentially, your lordship used the phrase, quote, indirectly, total control of the management of the company. Now, on that point, my lord, dealing with the issue of control, can I ask your lordship to take up my friend's authorities at tab 10? Because he cited an important paragraph from that case, and relying upon, I suspect, trying to say that we are bound by it, and we accept, sorry, paragraph 12, tab 10, we are bound by it, and so is my learned friend and the government in this case. Does your lordship have it?
Yeah, yes, I do. Which paragraph?
Tab 10, paragraph 12.
Yes.
The corporation, says the former Chief Justice, is ultimately controlled by those who elect its officers. Well, my lord, if you just deleted the word elect and put in appoint, it's again, that's a distinction without a difference. But that is who controls the corporation. Now, that is a finding by the court, this court, in relation to the corporation and in relation to the government. And my friend and the Attorney General is bound by that. There is a finding by this court of control in the event of by those who elect its officers. Then there's no difference between that and appointment. It's actually a moot issue, my lord. The issue, but I was just touching on your lordship's point about control. It is a moot issue. This point has already been determined by this court in relation to these parties. I'll come back to it to some extent in any event, but I think that is the hopefully simple answer.
My lord, can I just interrupt for 5 seconds?
Please.
Just to, if it might help, I think your lordship's question is this: if one seeks to apply Papinet and Lawrence, which relate to different circumstances of private companies, how conceptually does one apply that to the circumstances of a public body such as a corporation?
Yes.
I think one starts with the proposition that the Constitution is capable of applying to public bodies, and that's clearly the intent, because otherwise the exception in subsection 3 of section 13 would not be necessary. It wouldn't be necessary to make that specific exception. Now, in relation to exceptions, I think it's fairly trite that you don't create exceptions out of nothing in order to limit the expansiveness or the measure of the protection that's given by the constitutional rights. And in essence, the argument that I think that is being raised is that there is some sort of, I guess, implied exception or inferred exception in relation to bodies such as the corporation, because it's a corporation that has public purposes, because it has a certain kind of relationship with the government, i.e. central as opposed, and local government. But the difficulty, I think, is that there is nothing in the language of the Constitution that leads one to that conclusion at all. It just isn't there. What's in the Constitution, in fact, is the exception that is set out in subsection 3 of section 13, which relates to a particular kind of public body and the parameters of which are carefully drawn in the language of subsection 3. And one has to look at that language very carefully because this is an exception.
Yes.
So let's just say, for the sake of argument, that the Constitution is capable of applying to public bodies. So the next question is, how does one then look at cases like Papinet and Lawrence to see whether they're applicable in the case of public bodies. I think in order to do that, one has to look and see what is the underlying rationale of those cases. The underlying rationale of those cases plainly is that when control becomes too much, it goes to the point where those bodies in fact don't have control over their own property, then that constitutes a deprivation or a taking. Now, so what you have to ask yourself, it seems to me, my lord, is the concept of control capable of being applied in relation to public bodies or statutory corporations? And I think the short answer is, of course it is. They are controlled by a certain kind of management. And if you then impose controls on that management by the government, the analogy is exactly correct. You are then saying that whatever property that company, that corporation, that entity owns is now being controlled by the government. So conceptually, the analogy works in terms of what the underlying test is. So that's the first point. The second point is that there is nothing in those cases that relies on those companies being private companies. Those cases don't turn on that. So for example, those companies won't say that we are being deprived of business goodwill. Because there are certain cases where companies say, oh, well, the merchant cases, we have been deprived of our goodwill because you've destroyed it by this legislation, say in the case of Societe United Dogs on those cases. But those companies weren't claiming that what was being destroyed in that case was their business goodwill. So there's nothing specific about the claim that links it or attaches it to the kind of property that only a private company could possibly have. And then one goes on to the question of the shareholders' proprietary interest. I recognize that your lordship sees that that is a kind of property that's well recognized, and that if you take that away, it would constitute a deprivation. But that was not what was being argued in those cases. Firstly, it wasn't being said, oh, well, I'm a shareholder and you're taking away my proprietary interest in the company. That's the first point. The second point is that, I'm sorry, my lord,
No, that's fine. Go ahead.
The second point is that, so what follows from that is the fact that the corporation doesn't have shareholders, is nihil ad rem, is sort of nothing to the point, because that was not what those cases turned on. So in order to in seeking to apply the analogy, firstly, one looks to see what's the underlying rationale, whether it's applicable, and we would submit that it is applicable. And secondly, one then looks to see whether or not there's something about those cases that turned on the private nature of the entities which were under consideration in those cases. And we will submit that there is nothing there.
Yes.
So in answer to your lordship's question about how or whether these cases are applicable, we would say that they are applicable by analogy, and we accept the facts are different, but they are applicable by analogy because there's nothing about those cases which makes them inapplicable. Yes. And in relation to that point, my lord, that's what I have to say.
Thank you.
Just to wrap up that point, my lord, it is not for us to come before the court and set out for your lordship what we consider would be appropriate, an appropriate level of control. We are here because we have this set of facts, and our position on that is based on this set of facts. There is such control as to amount to a well, it's certainly deprivation of property under Section 1 and or a taking, constructive taking, if I can put it that way, under Section 13. And that is what we are faced with. I accept, my lord, for the avoidance of doubt, that there is certainly an issue of, there can be issues or degrees of control that can be exercised, which chances are would be, quote, constitutional. That's not what your lordship is here today to deal with. Your lordship is here to deal with this set of facts and whether or not, yes or no, whether it is constitutional. And we say on the clearest of authority and on the facts, and in fact on the basis of the former Chief Justice's earlier finding, paragraph 12, tab 10, that there is control. We'll also move on, to, my lord, to deal with the question of or the issue of what is a public purpose or public function. It does seem that my learned friend, and if I may say with respect, my lord, to some extent, your lordship, have been assuming that these phrases must mean interchange or can be used interchangeably with government purpose. Respectfully, that is, we would say, incorrect. Of course, the government does not always act in the public interest, or in any way which would advance the public interest. The legislature, despite the government's majority, is still a separate entity. Indeed, with the simple point, my lord, and perhaps the obvious point, if the legislature always acted the way the government wished, the Senate would have already passed this bill. This also means that to say the powers of the corporation that have been given to it by the government is not quite correct. Those powers have been conferred by Parliament, and the corporation must exercise them for the perceivable purposes of Parliament's enactment, not necessarily as the government wishes. And while we're on that point, my lord, can we just take up one of the extracts my learned friend read to your lordship? It's at tab 8. It's the affidavit of Mrs. R, and it's section 10. At which act? The 1797 Act.
Sorry, which page are you at?
I'm sorry, my lord, I'm at page 12 to the exhibits of Mrs. R, which sets out the ancient legislation.
Yes.
And particularly, my lord, I'm going to ask your lordship to look at section 10, and then interestingly at section 7. So this deals with this was, your lordship remember Mr. Gosling's affidavit, which basically said freeholders basically had their land purchased from government, and then government divided it into lots and then sold the lots, and the monies were reimbursed to government. And this is what the section 10 is all about. Immediately upon the public of Bermuda being fully indemnified and reimbursed of and for all arrears arising or due of the same from the said township of Hamilton, the said township of Hamilton, and all in singular lands and lots of lands, tenements, hereditaments, within the limits of the same, with the rents, issues, and profits thereof, shall be vested, and the same are hereby to be declared to be vested fully and absolutely, emphasis on the words fully and absolutely, my lord, in the mayor, alderman, and common council of the said township and their successors and assigns forever, converted to the proper use, benefit, and behoove the said ownership, and I can't read, assigns forever, and to be by them converted to the proper use, benefit, and behoove of the said township of Hamilton, and for no other use, intent, or purposes whatsoever. So certainly back, and I appreciate the law has moved on, but certainly, my lord, there's no question that those lands that the corporation had acquired in 1797, it held them absolutely. So it doesn't say for the benefit of the government or for public purposes. It specifically states it is for the benefit of the township, and then says, and for no other purpose whatsoever. That is important. And then, my lord, interestingly enough, and this was a rather interesting comment by my friend, and I'm sure it wasn't deliberate, but it goes to the point your lordship seemed to mention yesterday about whether the corporation was involved in business, if I can put it that way. Your lordship was asking me questions about investing in business and does the corporation do business? Well, section 7, the said mayor, alderman, and common council for the time being and their successors shall and may have power and authority under their common seal to choose, nominate, and appoint such and so many officers as they shall judge necessary for the conducting the business of the said corporation.
Well, that doesn't mean business. That means running the corporation.
Yes, my lord.
Begs the question as to whether the corporation is doing any commercial business.
Well, my lord, well, my lord, if you mean commercial business with a view to making a profit for the benefit of its shareholders, then your lordship may have a point. But there can't be any dispute that the corporation is involved in business where, for example, it is renting out its property to tenants and receiving a rent for them. I just put that as an example.
Yes. So, Mr. Deal, it's 11 o'clock.
Oh, sorry, my lord. Yeah, certainly.
Let's take a 15-minute break, and we'll
Yes.
resume at 11:15.
Thank you very much, my lord.
Thank you, my lord. No.
Yes, Mr. Deal, we can proceed.
Thank you, my lord. If I could just return to the point, the express exception point of section 13.3.
Yes.
Your lordship will remember that the wording, it relates to public bodies, and I'm quoting, established by law for public purposes in which no monies have been invested other than monies provided from public funds. Now, the Attorney General's, my learned friend's argument here appears to be that because the corporation must exercise its powers for public purposes, as soon as any monies come into the hands of the corporation from any source, they become public funds. In fact, I think my learned friend actually confirmed that this morning. The difficulty with this argument is that the section requires that such monies be public monies before they come into the hands of the corporation. So emphasis on the word from, my lord. So the monies must first be public funds, which are then invested in the corporation. And we talked earlier about the Fisher approach to construction, my lord, and this conclusion, we would say, is only strengthened by the applicable interpretive principles, which exceptions must be will be construed strictly and must be strictly satisfied. And then if I could just return to the investment point. At the risk of stating the obvious, this is investment, this is contained within an exception, my lord, section 13.3. So in order for my learned friend to bring himself within the exception, it is his duty to establish, firstly, that there is investment, whatever that may mean, and secondly, that investment must be from public funds and exclusively from public funds. As I think I said yesterday, there is no evidence which demonstrates or from which it can be inferred that no funds other than public funds have been invested in the corporation. And my lord, indeed, we would say there's evidence to the contrary. See, for example, section 10 of the 1797 Act, which I just read to your lordship before the break.
Sorry, what was the point with that act?
Section 10, my lord. Remember the section.
The business of the corporation.
No, that's section 7. Sorry, section 10 was the one that said all lands, etc., vest in the corporation absolutely.
Yes.
So that didn't come from public funds. Those lands came, as we go back to Mr. Gosling's third affidavit, those lands came from freeholders, were sold to the government. Government divided them into lots, sold them back to landowners, and the investments were then paid back to the monies were then paid back to the government. So there was no investment by the government in that enterprise, because the government got completely reimbursed. And I'm merely using that as an example. But the simple point I'm making, my lord, in any event, is that it is for the Attorney General to lead evidence to say that they are within an exception. It is not for us to lead evidence to say we're not within an exception. Then if I can move on, my lord, to the, if I may say, rather surprising assertion that the corporation is not a person entitled to assert constitutional rights. I sent up, hopefully this morning, my lord, the case of Antigua Times.
Yes.
Did your lordship receive that? I'm grateful. And I hope my learned friend got it. We sent it electronically.
Yes, I see that.
I'm sorry. I was hoping my friend had got it as well.
It came in after we started the hearing, so I've just seen it.
Yes. No, sorry. That was when it was sent. So, yeah. So, my lord, if I could ask your, well, I'm going to go to certain extracts from Antigua Times, but for your lordship's note, that the relevant passages are at, from the extract from the case are 235H to 240A.
Yes.
Thank you, my lord. I'm not going to read.
I've read the head note.
I'm grateful, my lord. If I can just deal with two passages then, my lord, or if I could deal with it this way. First of all, this is 1975 law. It is a decision of the Privy Council, and it deals specifically with the issue of whether corporations are or companies are persons within the and thus within the ambit of constitutional protection.
I see that Mr. Harvey DaCosta QC came in second.
Yes, well, I'm sure one of his rare defeats, my lord. Yes. I'll try and skip to the obvious sections, my lord. Sorry, I was operating from a different. The court goes through the exercise that we actually went through, or your lordship went through yesterday, in relation to their Interpretation Act, and applied that. And there was just one other section. Sorry, I'm going from a note, so I don't have but I think it might be useful.
It's basically the whole that a person includes a corporation.
Indeed, my lord. The only other point I wanted to pick up was the extract. Sorry, if I can just find it. I'm just trying to find the relevant. Yes. If your lordship could go to 239. And if I could pick it up at between D and E. This is dealing, again, this interestingly enough, my lord, dealing with the exception, what our sort of 13.3 point.
Yes.
The inference, this is what the court say, because this bolsters our point about, obviously, 13 includes bodies corporate, because otherwise there'd be no point in having the exception. And this is what they say. The inference is that, but for this saving clause, the property of the company, of the body corporate, in the course of being wound up, would or at least might have been affected by the section. A similar inference arises from subsection 4, which saves any law for the compulsory for the compulsory taking, possession or compulsory acquisition in the public interest of any property held by a body corporate, which is established for public purposes by any law, and which no monies have been invested other than monies provided by Parliament.
So where are you? 239?
My lord, I'm at 239.
Yeah.
I was started reading between D and E.
Yes.
Which says
Yes,
start.
I see that.
The inference is.
Yeah, I have it.
Could I just let your lordship just then read that to yourself again?
Yes.
So what they're saying is, but inferentially, obviously, their equivalent of our section 13 does apply to bodies corporate, and it's rather interesting their version of the exception, my lord, which is another way, if I may say, of putting exactly what I've just said to your lordship. In fact, I would say it's clearer, but it's the same as ours to all intents and purposes.
Yes.
Yes, and there is I will find the comment for your lordship, but I know I would say there is a comment in there. Perhaps my friend Mr. Myers can email me the relevant passage, but the board does make the same point that your lordship has made yesterday, that this type of protection inures particularly to the benefit of corporate bodies who will be particularly affected by or acquisition or could be particularly affected by acquisition of property or taking of property. It was the same point your lordship made yesterday.
Yes.
So just we would make the sorry, my lord, I'm just sort of gathering my thoughts in relation to some of these notes. The corporation submits that it is made out all the necessary elements of its constitutional claim, assuming for the moment the enforceability of Section 1 or the wide construction of Section 13, which we have advanced. And I hear my friend on those points, but it becomes...
So when you say the wide construction of Section 13, this is the literal construction of the words and also the control points.
My lord, yes. Not only the control points, but again, the generous and purposive construction that it includes body corporates, and the control points, yes.
Yes.
That Section 13, the Papinet and Lawrence line of authorities. Yes, my lord.
Yes.
Although we would say on that point, though, my lord, although Papinet and Lawrence may not relate to corporate bodies established by law for public purposes, my learned friend, Mr. Myers, covered that with you before the break, but your lordship has our submissions on that point. I don't think I need to go over that. Then dealing with the McLeod case that my learned friend referred your lordship to.
Yes.
Yes, that was, I forget where, I think it was tab 23 of my friend's bundle. I have a couple of comments in relation to that. I have too many pieces of paper floating around.
I have tab 23.
I'm glad your lordship does, because I'm still rooting for my copy. Sorry. Yes. Sorry. If we could, just for ease, my lord, go to the head note, because I think the head note on there's no page numbers on this, but the actual third page right at the very top that starts per curiam.
Yes, we looked at it yesterday, I thought.
Well, yeah, we didn't. We looked at the actual body of this decision, but this encapsulates.
I have it highlighted.
Oh, okay. Then I apologize, my lord. For Parliament to purport to make a law that is void because of its inconsistency with the corporation deprives one of protection of law so long as the judicial system of Trinidad and Tobago affords a procedure by which any person interested in establishing the invalidity of that purported law can obtain from the courts of justice a declaration of its invalidity that will be binding upon the Parliament itself and upon all persons. And my learned friend, I understood to be making the point, saying, well, you have common law remedies that could be advanced as opposed to constitutional redress. I would ask the rhetorical question, my lord, is what common law remedies in circumstances where the minister has appointed a new board of directors be able to challenge the legislation appointing that board? It becomes circular. Not only that, assuming there was such ability, which of course there isn't, how would any decision be binding upon Parliament itself. That is the specific reason that Section 15 exists. Because your lordship has, among one of the tools or weapons, if I can put it that way, at your disposal, is the ability to declare the legislature or a piece of legislation unconstitutional and to strike it out. That doesn't exist in other legislation or other common law remedies. And in any event, my lord, if you can go to, for your lordship's note, I'll read it out. It's at page 531 of the decision. This is not a case which purported to provide a comprehensive assessment of the scope of protection of law. And this is what they said, my lord, at 531. It starts, their lordships have been invited. Did your lordship see that paragraph?
Yes.
By the appellants to supply a comprehensive definition of what is meant by the expression, the protection of law. This is an invitation which their lordships consider that they must decline in a case in which, owing to the respondent not being represented, they have not the benefit of adversarial argument. So therefore, my lord, the force of this authority, therefore, even if applicable, is much diminished. Further, we would say the matter was subsequently dealt with in cases such as Lewis, Nevasive, and obviously Jamaica's for Justice, in terms which plainly expanded its scope far, far beyond the limitations of MacLeod, which, as your lordships can see, is a 1984 case.
Well, that's been one of the reasons why they say Section 1 is directly enforceable, because they say that protection of law as contained in Section, our equivalent of Section 6, is so narrow.
Yes, my lord. And,
well, Caribbean jurisprudence.
Yes.
But can I just interject just one small point, if I may? On the issue of protection of law, I think that it can be said that the Privy Council agrees that that particular aspect of Section 1 and all the other introductory sections, that particular aspect is enforceable, because they could not explain the result in Lewis otherwise. So if you look at Lord Mance's judgment in Newbold, in that case, Lord Mance accepted that, in fact, Lewis has that impact, that protection of law goes beyond that which is provided for in the specific section, and that it can be enforced independently. So it's kind of odd, because the case law seems to say that there is a kind of distinction between the protection of law right as it is set out in Section 1 or the introductory sections and anything else that's in that section.
Well, they also say that as a matter of common law, those rights are there.
Well, the rights that are covered by protection of law?
No, the rights which are expanded upon in the Caribbean cases. The breadth of the protection of law clause.
They identify protection of law with due process, and they go back to the old cases of Thomas and Baptiste and those cases to say this is the rule of law, and it means a rationality, certainty, etc., etc. Yes. I'm sorry.
It was the points we were dealing with yesterday, my lord, when your lordship asked me about protection of law. Was it arbitrary? Was it fair? Is that we cited the extracts from relevant authorities, my lord, just to basically demonstrate what the courts now consider to be aspects of protection of law.
Yeah. Can I just add, though, sorry, that yes, it may have derived from the common law, but the case law has now constitutionalized the common law, so that legislation can now be tested against it. If it was just common law, obviously, you couldn't test the legislation against it, just to make that clear.
Yep. And then, because my friend was making the point yesterday that this was dealing with the right of access to the courts, and basically saying, well, that hasn't been hindered. My lord, we do pass up for your lordship, and this does deal with that. This is a sort of, unfortunately, it's just recently occurred. the issue of the results of the corporation's application for budgetary approval, and that was the second document that was sent up to your lordship, and you will see there on there the minister's note in relation to the corporation budget that approves the budget, save for any expenditures on legal expenses in actions against the government, i.e. these proceedings. So, my lord, it doesn't, with respect, it's a point I don't like making, but it's made because my learned friend yesterday and this morning made the access to the court's point. And it is indicative, unfortunately, of the tactics that are being employed by the government to prevent the corporation, even trying to prevent the corporation from even getting to court. So at the moment, I will say in fairness, the corporation through us has written back to the minister, and he is now, quote, reconsidering the issue. But that was his first reaction, or the government's first reaction, is to say, and it goes to the control point, my lord, as well, that we're going to approve your budget, but you can't spend any money where you're going to take any actions against the government. If that is not interference with right of access to the courts, then I don't know what is. And then the point made by my learned friend in relation to, he took issue with my description of the minister being able to fire and replace directors at whim, or officers at whim. And he referred to paragraph 9, I think, of the 4th schedule. But that paragraph permits the minister to fire not only if the minister is disqualified, or so the member is disqualified, but also where he's, quote, unwilling to carry out his functions. So given the minister's power to make mandatory directions or give mandatory directions to the corporation, which are then deemed to be for municipal purposes, i.e. essentially amending their legislation, and to constitute lawful functions of the corporation, the member could be fired simply for, quote, being unwilling, which, be it noted, is not the same thing as refusing to carry out the direction. So any indication of unwillingness to follow a ministerial direction, therefore, renders the member liable to removal. We would say if that is not whimsical, then one wonders what is. At one point, my learned friend made and there's no evidence on this, but made the submission that following on from amendments reinstating, so this be back in 2013, the 2013 amendment, my lord, reinstating the business ratepayers vote, if I could put it that way, that this resulted in a situation of people within the corporation or ratepayers having 2 votes as opposed to 1. Well, firstly, my lord, there's just no evidence of that. Had that been in evidence in Mr. Azar's affidavit, we would have specifically dealt with it. In any event, my lord, what they do is to try to support that contention. They simply say, well, here's the number of votes that were cast in the 2010 election when you didn't have business ratepayers voting, and here's the amount of votes that were cast in the 2013 election. And because there were a lot more, that must mean there were 2 votes. 2 people were voting twice, once as resident, once as business owner. Well, my lord, with respect, again, that is a conclusion, and it's wrong. We would have given evidence had that been asserted. But what it simply shows, my lord, is that not surprisingly, in a area which is specifically designed to promote and benefit commerce, business ratepayers are voting.
Do you accept that the business vote was only recently introduced, either in 78 or 72.
Yeah, I think that's right, my lord. Yes, I mean, and you know, for the avoidance of doubt, the history of voting, and whether it doesn't make any difference whether it's a corporation or for national elections, has not been a happy one. Obviously, with racial issues, disenfranchisement of women, and so on, and also obviously landowners. So what we have now is a situation where you have a residents able to vote for a residents representative on the corporation, and businesses who can vote for a business representative on the corporation. And my lord, that is the current state of play. That hasn't been tampered with in the last 7 years, and that's where one would say, particularly where businesses, and this is again in Mr. Gosling's third affidavit, where businesses are paying the lion's share of the rates compared to residences, it is only proper and right that they have a say in who should be running a commercial, an entity which is there to benefit commerce. The fact that no ratepayer has applied to the court for constitutional redress is a point that my learned friend has made. Well, my lord, firstly, for example, I think my learned friend Mr. Myers touched on this morning. That was when one of his interventions. That was, you'll note in the case of Lawrence, there was no application by shareholders. There's a fundamental difference between shareholders' rights or shareholders' ownership of property. They don't own the property of the company. This is trite law. The company owns its own property. And it was an application by, in this case, the Lawrence case, the general manager of the bank, for and on behalf of himself and the bank, in relation to the deprivation of the bank's property, which in this case amounted to its management abilities. So the fact that no ratepayer has made an application is neither here nor there. But your lordship should also remember, obviously, the simple fact that all of the members of the mayor, the aldermen, councillors, etc., are ratepayers. They are ratepayers in their own sense, in their own personal standing, or representing a business which votes as a business ratepayer. So if that point had any validity, there are the ratepayers represented via the corporation itself, the aldermen in their personal capacity as ratepayers who are concerned. And finally, what I would describe is the chilling effect of the Attorney General's, my learned friend's, contentions, which is in essence that companies formed by public acts and not given the rights of natural persons therein, and if formed for some public purpose, are not subject to constitutional protection, and particularly Section 13, would mean, my lord, that the government has the ability, and we would just put these out as examples, to take over, for example, the following: Belco, Telco, Bermuda Aquarium, and, my lord, I would ask your lordship to have a look at the Bermuda National Trust Act, 1969. In that case, for example, that is very right on point. There are no shareholders in that piece of legislation, and the minister already has the power in that to appoint, as I said earlier, a minority of officers. So it'd be a very simple thing for the legislation to, or the government through the legislature, to amend the legislation to remove the ability of anyone else to appoint officers, so that the government would have complete control over some 277 acres of National Trust land. Well, Lord, that just cannot as a matter of common, dare I say it, common sense, be right. My learned friend this morning was referring to various questions of control, and one of them, my lord, that he referred to was the minister has to approve council resolutions. I would ask your lordship to bear in mind the fact that Mr. Gosling's affidavit evidence, and he goes into considerable detail on it, that basically the Attorney General and the minister haven't approved any of these resolutions.
But that just shows that the system may not be working.
Well,
his point was that there already is control.
No, well, my lord. There again, you come to it. It comes down to a question of fact and degree.
Yes.
Yes. I'm sorry. I'll leave the point. I would also ask you, but then my friend then went on after that to discuss the issue of parliamentary sovereignty. Again, at the risk of stating the obvious, my lord, this is not a jurisdiction of parliamentary sovereignty. This is a jurisdiction of constitutional sovereignty. And then just dealing with some of the points. Yes, my friend was making the point. I think he said it goes without saying a public body is subject to control by central government. If there's executive overreach, then the proper route is judicial review. Well, my lord, again, how can one JR the appointment of management of the corporation, which is done by statute? The statute is amended. Pursuant to that, the minister appoints the entire new body of the corporation, assuming the corporation would even be able to do it. But how would they JR it? And in any event, if they did, that is a demonstration of unwillingness to perform their functions, and the minister under the Act could remove them. My friend, I noted your lordship's note did not deal with at all the issue of the loss of 5.75 million under the heading of wharfage. Didn't deal with that at all. I'm sorry, my lord, I'm just going through my notes.
No, that's all right. Take your time.
Thank you, my lord. My note says I should go to paragraph 51 of tab 10. I can't, to be honest, I can't remember why.
Which tab 10?
I'm sorry, my lord, my friend's tab 10.
Ah.
I don't, my lord, sorry. I don't need to take your lordship to
I think
that.
you've been there a couple of times.
Yeah, we don't need to go there. Yeah, just to pick up a comment by your lordship from this morning, when we were dealing with the section 13.3 point, or with my friend, your lordship made a comment about, if I may say, a sensible comment, that in relation to 13.3, where there is a circumstance of a public body that has been, stay with the words, the investment has been solely from public funds, to say, well, why in those circumstances it makes no sense, because there would be, to use your lordship's expression, simply an internal transfer of funds. Well, Lord, applying that to this case, there's no internal transfer of funds in this case. It just wouldn't arise. My learned friend made the point, he says that Inchcup considered Malpas and that settles the issue. think your lordship has our submissions on that point. That is simply wrong. The point is that the Court of Appeal wrongly said that it wasn't bound by Malpas, because it was per incurium, which is, and we can see that, my lord, is demonstrably wrong. Your lordship said,
On that
sorry.
point, I understand what you're saying, but what do I do with the fact that the Court of Appeal actually made a determination that Malpas was per incurium and wrong? I mean, do I just ignore that, or am I bound by that?
Well, my lord, I think your lordship, in my respectful submission, is fully entitled in those circumstances to say, I am faced with two conflicting Court of Appeal decisions, one of which has been characterized, and respectfully is difficult to see how, as per incurium. And your lordship, in my respectful submission, has the ability to then decide as to which of those you're going to follow.
So I
understand your lordship's point.
Overrule the Court of Appeal decision to the extent that it says it was per incurium.
Per incurium. Well, again, my lord, that is not that isn't ratio of the Inchcup decision, because once again, Inchcup was decided on other points. So that is not your lordship isn't bound by that ruling, by that aspect of that ruling. That is not the ratio of the decision. So your lordship can sit there and say, yeah, well, actually, that was their contention. It wasn't part of their, wasn't a necessary part of their decision. Accordingly, I am not bound to follow it. I am bound to follow Malpas, I would respectfully say. But your lordship, that is my first contention. But in any of the four, as I said earlier, the fallback contention is your lordship deals with. It could deal with, if I could put it this way, deal with it afresh. And one other point on Inchcup, I'd ask your lordship to note and remind your lordship that in Inchcup, the Court of Appeal said it was specifically dealing with the issue of whereas. It wasn't dealing with it. That's the aspect it dealt with, and it characterized the wording as the phrase or the word as unfortunate.
No. He said, in all fairness, the final paragraph of the judgment said that it is unfortunate that we have to make a decision on the word whereas, but that's how it is. I mean, he wasn't expressing that the decision was, he made it reluctantly. All he was saying was that when the court makes a decision based upon just one word, it may seem odd, but that's how it is. Well, that's how I read it.
My lord, the way I was reading it was, yeah. Well, perhaps I think we get there slightly different routes, but yes, the way I read it was, the fact of the matter is that the court was looking at the issue as to whether or not, whether or not Section 1 was independently enforceable is going to be determined by one word. Yes.
Yes. Yeah. But yes. I mean, the judge was quite clear. The Court of Appeal was quite clear in that case that the decision in Inchcup was plainly right.
Oh, well, Lord, I can't shy away from that. But your lordship,
they said that the decision in the Malpas case was plainly wrong.
Well, as I've said, my lord, and I've given you the principle of stare decisis. They can't do that.
Understand that point.
Yes. Finally, my lord, dealing with my learned friends, on my notes, finally dealing with the issue on consultation.
Yes.
Where my learned friend was making the point that there's no statutory requirement for consultation. But that misses the point, my lord. The issue that we have raised on the failure for there to be consultation is that failing to do so results in legislation that in this case is arbitrary and unfair, and in so doing is in breach of the protection of law provision in Section 1. Further, my lord, and you have evidence on this, the results of the consultation, such as it was with the corporation, which was scant to say the least, and with the public, which was more significant, was that that consultation was, to all intents and purposes, ignored, because the overwhelming majority, the results of that, was against what the government was proposing.
That would be quite a challenging submission. So the court would be faced with having to decide whether the government followed the consultation.
I'm sorry, but I hadn't quite finished the point. The point I was making was, in such circumstances, in order to deal with, so it doesn't appear arbitrary or unfair, what one has to do is to explain. If you're sitting there saying, right, I've now consulted with you, everyone I've consulted with is against it. I am, irrespective of that consultation process, I'm going to go in the other direction. You have a duty, I would say, to explain why you did so.
Well, I mean, they've tried to explain. You may, obviously, you disagree with that, and you made submissions in relation to it.
Well,
but Ms. Azar's affidavit tries to explain why they've gone the way they have.
No, she doesn't explain why they have completely ignored the consultative process, the results of the consultation.
Are there any cases where the court has held unconstitutional primary legislation by the legislator on the basis that there was lack of consultation?
I don't know, my lord, I have to say. But we have case law that your lordship is aware of, and off the top of I'm remembering cases where the minister has received reports of experts, for example, I think planning cases spring to mind, and where the planning expert has said, I'm going to recommend X, and the minister nevertheless does Y.
Well, those are statutory provisions. I mean,
sorry, yes, but yes, my lord. We're actually dealing with constitutional provisions.
Yes, but I mean, primary legislation is ultimately a matter of policy, and it is for Parliament to decide what the primary legislation should be. It would be. I want to hear your submission. It would be unusual and rare for a court to say, we are going to hold this legislation which Parliament has passed as unconstitutional on the basis that there wasn't adequate consultation.
No, that's not the point, my lord. Well, it's the point in relation to the corporation. Firstly, we say there wasn't adequate compensation. QED, it's unfair. But we're also saying in relation to the consultative process that you undertook, where the results were completely and utterly against what this government was proposing to do, and that is consultation with the public, no explanation has been proffered as to why, despite that process, they've decided to continue. That also is arbitrary, capricious, and unfair.
But I mean, that's again a challenging point. The government could quite rightly take the position that the consultation which has taken place shows that the majority of the people are against it, a particular proposal. But for longer term interests, other policy issues, they may determine that it's still in the national interest for a particular proposal to go ahead. And
that's my lord, that would be the explanation they would have to give.
But
where is it?
Do they have to come to court to explain themselves?
No, my lord, no, they don't have to. What they ought to be doing is, before enacting the legislation, is to say, we have considered the pursuant to this consultative process, and despite that, we are going to continue, and here is why. But that didn't happen.
Yes.
Or let me put it this way, there's no evidence of it happening.
So maybe I can just intervene just for 1 second again.
Yes, of course, Mr. Myers.
Thank you, my lord. It might be helpful to look back at the case of Jamaicans for Justice, which is at tab 22 of our authorities.
Yes.
And if you look at paragraph 22 of that case, which is on page 125, which I think we've taken you to before.
Yes, we looked at it yesterday.
Yes. So at the bottom of that page, this is where they sort of cite Nervey and Severin with some degree of approval. I think we have to accept. And then on the top of page 126, it says the court went on to say of the right to the protection of law that, quote, it affords every person adequate safeguards against irrationality, unreasonableness, fundamental unfairness, or arbitrary exercise of power. And then says this is an echo of various previous cases. So I accept, well, we have to accept, obviously, my lord, that it is a challenging submission to make to say that your lordship is sort of placed in judgment of the things that the executive does or that parliament does. But the difficulty is that it's unavoidable under the constitution that that you must be in that spot, because what you have to determine, it seems to me, is whether or not any power, whether it be a legislative power or an executive power, has been exercised in accordance with the constitution, and to measure that power against the constitutional requirement or the imperative of the constitution. You now have case law that says that protection of law means these things. So it's quite unavoidable, it seems to me, excuse me, hello, at least in our submission anyway, you kind of placed in a difficult spot, I accept, but it's unavoidable. You have to try to apply the Constitution, and the case law tells you the Constitution protects against all of these various things, which I accept are broad and perhaps a little bit vague. But so if you are faced with a piece of legislation that is arbitrary and irrational, that is a breach of protection of law on this line of cases. And I accept that it seems odd, but that's just what the law is. Hello.
Yes.
Thank you. My lord, then just some sweep. Sorry, my lord, you were going to say something?
No, that's fine.
Thank you. Just some other couple sweep up points, my lord. Just to clarify, my lord, because I think it was in relation to a comment by your lordship this morning in relation to, I think your lordship said that our primary complaint was in relation to the, quote, majority vote, I think was your lordship's phrase.
Yeah.
Well, my lord, it's, as your lordship might appreciate, I'm sorry if we haven't been clear, but it's not just the issue of majority vote. You have to look at it when combined with the other powers of the minister. For example, not just the majority vote, but the power of the minister to replace those unwilling when looked at with his ability to give directions and determine what a municipal purpose is. So they
what I meant was, it was your primary case is one of control, the issue of control.
Yes.
In different ways.
Yes, my lord. Sorry. Thank you.
This is not a case where there's taking in the traditional sense. There is no taking in the traditional sense, and the only way you can really attack it is on the basis of control. My
lord. Your lordship. I was just merely picking up the comment about the majority vote. It's. Yeah. Thank you, my lord. Sorry. So I'm just scrolling down some comments, my lord, to see if there's. So I think. Yes, my lord, unless I can assist your lordship any further, I think those are my submissions.
Yes, thank you. Was there did you want to say anything else, Mr. Howard, anything arising?
Well, there was a matter arising which I feel compelled to address, and that is the marginal notes of the minister provided after the hearing started this morning. Mr. Deal indicated that this is a matter that just came up. In fact, it isn't, and he may not recall because I think Mr. Myers may have been dealing with it, but it's in fact a matter that goes way back to the beginning of this proceeding and in early 2019. And I don't think that that it should be considered by your lordship because the matter isn't really in evidence, and it's not, and there's lots of communications back and forth. The point that I think Mr. Deal was trying to make was that it's indicative of the kind of control which is going to prevent the Corporation of Hamilton getting access to the court. In fact, that has not happened. This particular issue goes back some time, and at no point during this proceeding has the corporation been so hindered. So if the court is going to need more factual underpinning to make it an indication based on that issue.
I somehow don't think that my decision is going to be
Didn't think it would.
decided by that point.
I don't have any further matters in reply.
Well, I think in that case, thank you very much for all your work and those interesting arguments. I will obviously consider them with care and let you have a written judgment as soon as I can. Thank you.
Thank you, my lord.
Thank you, my lord.